Okay, it's 2 minutes past 9, so I will just kick off with the sort of introduction things, and then obviously Liam will continue to let people in as we go. I'm joined here by my colleague Liam from our events team, and my name is Ann Horne. I'm a kinship consultant at Core and Bath. There's also, I work with my job share Clare Seth, who's on annual leave this week. So it's just me presenting today. But welcome. This is the first of our 2025 series of Getting Started, which is a series of sort of getting started when we're thinking about permanence for children who need it outside of the care of their parents. So the aim of the session is just a very brief introduction to some of the kind of key sort of concepts and information around kinship care as a potential option for children where there are safeguarding concerns or who, are unable for other reasons to continue to live with their parents. It is sort of introductory level. It's aimed kind of at AYSEs or student social workers or perhaps those who are new to working with kinship families. But we are aware that there is quite a diverse audience here today. So hopefully there will be something here for everybody. At the end, there is some signposting to a bit of resources and some practice tools, as well as some introduction to relevant legislation around kinship care. But there are also other other events in the Getting Started series, and there is one, a legal session in a few weeks. And again, the information about that is on a slide at the end. And like I said, I will hopefully be able to allow sort of 5 or 10 minutes at the end for Q&A at the end. Language matters, and therefore this is a sort of explanation of how we've arrived at the decision we've made as an organisation at Core and Bath to use the language of kinship care. We know obviously that the current legislation and regulation, a lot of it still refers to connected persons and family and friends carers. And therefore in any of our sort of materials or content, when we're quoting or referencing legislation or regulations, then obviously we use that language. But otherwise, Core and Bath have made the decision to adopt the term kinship care as an umbrella term. And we do think it reflects the current national conversation around kinship care. It's definitely kind of more inclusive, and we're hoping it's working towards having more universal understanding. Without a doubt, though, there are kinship families out there who don't necessarily sort of recognise themselves as a kinship family. So there is still a lot of work to be done to ensure that kinship families do know what, support they're entitled to and how to support that under the umbrella of sort of kinship care. And I think it's important as professionals or practitioners that we think about the language that we use because it should have meaning for families. And I've always felt in all the years I've worked with kinship families that the phrase connected person has not particularly felt congruent for me with what is often a very familial, loving and trusting relationship between a child and somebody in their family or very close to them as a family friend or somebody that they have a relationship with. I've always felt personally I wouldn't like to be described as a connected person, but that's obviously, my individual view. But we have therefore made the decision to use the phrase kinship care. But obviously what we're not saying, and we say this at the beginning of any of our events or kind of training in relation to kinship care, is we're not telling you can't use the words connected person or family and friends carers, because we understand language is habitual. And if that's what you're used to using, we want to have conversations about kinship care. So please continue to use the language that you're comfortable with, but we're just explaining our rationale for the choices that we've made. So what is kinship care? Kinship care is any situation in which a child is in the care of a friend or family member and not their parent. The arrangement may be temporary or longer term. This definition has been established now in the first ever National Kinship Care Strategy that was published in December 2023. And it's also referenced in the Kinship Care Statutory Guidance that was published in October 2024. It's not a legal definition, but it is now a standard definition that's been accepted by the government and the Department of Education and will now be the definition that's referenced in all further sort of guidance and statute going forward. So it includes all types of informal kinship care. It includes special guardianship arrangements, child arrangement order arrangements, and adoptive arrangements where the adoptive parent is a family or friend. So there's been quite a lot of sort of policy and sort of practice sort of attention around kinship care in recent years. Many of you will be familiar. In September 2023, the government published Stable Homes Built on Love in response to the Independent Care Review. And there was a whole chapter dedicated to kinship care in the Independent Care Review. And obviously this was therefore reflected in Stable Homes Built on Love. In Stable Homes Built on Love, the government committed to publishing the first ever National Kinship Care Strategy, which they did therefore in December 2023. As recent as November 2024, the new government has then published a kind of policy position around children's social care, and there is some references to kinship care within that, in keeping children safe and helping families thrive. And as I said earlier, in October 2024, the government published the updated statutory guidance for local authorities, which is now called Kinship Care Statutory Guidance for Local Authorities. It was previously called Family and Friends Statutory Guidance back in when it was written in 2011. Sorry, I'm just checking through my notes to make sure I don't say too much, because obviously this is a short event. The strategy published in 2024, as you can see on the slide, it's called Championing Kinship Care, and it set out to establish the foundations for a future transformed kinship care system. The law requires us to prioritise kinship care, so it isn't just a sort of moral or ethical driver, although it arguably should also be, but it is also enshrined in the law. So in the Children Act 89, in section 2022C, there's a general principle that children should be cared for by their family or friends if they're unable to remain in the care of their parents. It's also in the Human Rights Act, Article 8 is the right to family life. So when we're working with children, we should give preference to children living with kinship carers if they cannot live at home. And that is the language of the law, but it obviously does need to be safe for the child to do so. So if a child does become looked after, or is at risk of becoming looked after by the local authority, we are required by law to plan for a child's future care. And that's obviously what the definition is of care planning. So the objective of care planning is to ensure a child has a stable, loving and secure family. And if that can't be with their parents, then it should be that we're looking to their extended kin network to consider them next. Obviously, care planning, and certainly care planning when we're thinking of kinship arrangements, is not always a linear journey. So it's not always, you know, this happens, then this happens, then this happens. And obviously planning for a child where there are safeguarding concerns doesn't always happen in a linear way. Unexpected things happen, crises occur, and it's a complicated journey. And obviously, while we're working with kinship families, we're also continuing to work with the parents in parallel, where we're trying to continue to provide social work interventions and support that will hopefully support and enable the parents to make changes so that the child can remain in their care. But care planning also requires us to kind of work in parallel and to kind of be also thinking of alternative scenarios, and therefore that requires us to think of alternative scenarios that might be that if this child can't continue to live at home with their parents, you know, where would be an alternative place for them to live. And obviously, you know, prospective kinship carers are already part of the family system. So it's often already quite a complex landscape with sometimes quite complex family narratives, complex relationships, and often, you know, complex histories within families. And they don't necessarily conform or fit with the social work processes and tasks that the law requires us to consider. So when we're working with kinship families, arguably we need to bend and lean into the family system to work collaboratively and in partnership with kinship families, and not require families to do all the work to fit into our processes and procedures. As we'll move on to as the presentation kind of continues, kinship carers haven't chosen to be in this position. They haven't made a decision to be assessed as a foster carer, they haven't made a sort of decision that they want to adopt a child, they haven't had the opportunity to plan. It's often a stressful, emotionally fraught, and anxiety provoking time for everyone. So, with that in mind, I'd like you just to take 3 minutes to just individually, we won't obviously do this as a large group because there's too many people on the call, but just take 3 minutes for yourself to pause and just to do this exercise. So, identify a child in your network who you love and care about. And that might be a sibling, it might be a grandchild, it might be a niece or a nephew, it might be a family friend, and just pause and think about imagining that they came to live with you, that you received a phone call from a social worker explaining, that a crisis had happened, that the child was unsafe living at home with their parents, and that you were being asked basically to look after the child, that night. So just pause and sort of sit with that for a moment, and then list down in what ways that would impact on your life, on your partner's life if you have one, on other family members that you perhaps live with, or other people that you live with in your household. And just list down a few ways that that might impact on you. And that could be in ways such as on your accommodation, on your work, on your relationships, on the car that you drive, on your leisure activities. And I'll just give you 3 minutes to do that. And also think about why you would want that child to come and live with you. So I'll just give you 3 minutes to do that. Okay, so I think that was the 3 minutes. So obviously, if we were a smaller group, we would sort of take feedback from people about the experience of doing that. We do this exercise quite often when we train in kinship care and work with, social workers, panel members, just to kind of give people, just even for a couple of minutes, the opportunity to sort of put themselves in the shoes of being a kinship carer, because I think it is quite a sort of unique situation that people find themselves in. And I think it's just quite important that we, as practitioners working with kinship families, kind of on some level emotionally engage with what that experience might feel like, because I think it's kind of fundamental to thinking about and working with kinship families, to think about their experience and what they bring to the situation in which they find themselves. And we often receive sort of very similar feedback, in terms of how people, do. Obviously, it is, a massive shift that we're asking of kinship families to make when we ask them to consider caring for a child in their network. What we would encourage you to do is potentially take this exercise back to your team, perhaps in group supervision or in a team meeting, or a practice development kind of opportunity, and just, perhaps do it as a team and kind of just, sit and sort of have the opportunity to talk to each other and to colleagues about what it must feel like, or what it might feel like to be a kinship carer, and then to kind of reflect on how that might affect your practice kind of going forward working with kinship families. So some of the things that obviously often come up in the feedback when we've done this exercise are, around the sort of unplanned and kind of nature of kinship care. So if we think about sort of how much does sort of kinship care happen, so to speak, what's the prevalence of kinship care? We know from the 2021 census that reported that there was 121,000 children living with people other than their parents. But the 2021 census had some sort of data anomalies. For example, it didn't sort of include families with more than 6 children living in a household. So there has been some sort of work done in the sector to kind of adjust that figure, and therefore sort of experts in sort of data analysis and kind of experts in sort of kinship care have sort of agreed at a figure of it being at least 141,000 children living in kinship care in the UK currently. This compares to just over 80,000 children living in the care system currently. Obviously, some of those children in the 141,000 may also be children in care because they may be living with kinship foster carers. But that's just to kind of give you a sense of it is a huge number of children who are living with kinship families. And like other areas of the care system, we know from some of the data, of which the data that we have is quite inadequate in many areas, but we do know that children from minoritized, Black and minoritized ethnic backgrounds are overrepresented in kinship care, and they're particularly overrepresented in informal kinship care, not in formal kinship care. And as you'll sort of learn as the presentation goes through, what that does mean, therefore, is that those children are even less likely to be getting the support that they need as families. As we've sort of touched on already, and as you've obviously might have kind of emotionally engaged with yourself, in terms of doing that exercise, kinship care is often incredibly unplanned. It can also be described as the epitome of unplanned parenthood, because it's not something that people have kind of made a decision to pursue. Like I said, they haven't made a decision to become a foster carer or adopter. It's often very crisis driven. It often arises following concerns about a child's safety, about their well-being, often as a result of kind of a crisis. And therefore, like I've said, those kinship carers that you'll be working with often have very little time to think about things, to make decisions in a planned way, or even think about the consequences of what they're being asked to do. Obviously, the motivation that drives kinship carers is very different to the motivation that drives alternative carers such as foster carers or adopters. There's obviously some overlap, but obviously they are from a very different starting point. They're at a starting point where their motivation is to protect a child that they already know and love and who they wish to keep in the family. Sometimes the relationship with the local authority can be difficult. Some kinship carers have had previous experience of working with a local authority, and that may have a huge impact on their assessment experience with the local authority. There may be anger, distrust, potential experiences of having worked with the local authority themselves when they were a parent, and now they're again as a grandparent, or they may have experiences of working with the local authority as a child in care themselves, and then they are becoming a sibling kinship carer. So it's important that we kind of bear that in mind and think about that and afford ourselves the time to build kind of trusting relationships with kinship families, acknowledging sometimes those kind of power dynamics and the sort of history of a relationship with the local authority that's gone before. There's sometimes lack of clear information at the start of processes when kinship families start working with us, because it's crisis driven, and therefore they're sort of thrust into a sort of social work system that they may not be particularly familiar with all the processes that are suddenly kind of being required of them. It's quite a unique jigsaw puzzle kind of working in kinship care, because when we're working with kinship families, because we're working to fostering regs if we're thinking about a child in care and kinship foster carers. We're also working to the SGO schedule and what that tells us that we need to think about if we're potentially care planning towards a special guardianship order. And there's also still the live care planning going on for the child. And we'll be also, as a local authority, be thinking about whether or not that child can continue to live safely with their parents, or whether or not we do need to be considering alternative care. So there's a lot going on when we're working with kinship families for us as practitioners. And so therefore we also need to hold on to, there's a lot going on obviously for a kinship family who's suddenly been thrust into that sort of situation, with all of that to be considering as well. And there's also the timescales issue. Obviously, assessments of a potential foster carer, for example, or a potential adopter have hugely different timescales. A timescale of a prospective kinship carer, at best, it should be 12 weeks. The Public Law Working Group in its guidance sets out a sort of requirement of 12 weeks minimum. We know in reality that some courts are not giving local authorities that amount of time. We hear from our members very regularly that they're only being given 6 or 8 weeks, but which we would argue is insufficient time. The care planning regs around assessing foster carers allow us 16 weeks under a Reg 24 placement, with a possible extension to 24 weeks if a further 8 weeks is agreed. But that is still a relatively short amount of time to be working with a family who haven't had any time, preparation, planning to be thinking about where they've got to. So when we think about care planning, what we would stress hugely is the importance of the early identification of prospective kinship family members. So there's various ways, obviously, to go about that, either through formal family group conferences, if your local authority has access to a family group conference service, but other sort of forms of family group decision making are also kind of relevant. You can convene sort of informal family meetings. But what's important is that, if you're working with a child, if you're a child social worker in the room, if you're an AYSE or a student social worker and you're working with a child and the concerns are increasing about a child, the safeguarding concerns are increasing, it's incredibly important that you get to understand who else is important in the child's network. Who else could be enlisted to support the parents in their care of the child, or support the child in terms of kind of building resilience and offering kind of, sort of safety and offering sort of other ways to care for the child. But it's also important that you are also, while you're working with the family and getting to know the extended family, also thinking about who might be prospective alternative carers should it be needed, and having those conversations with family members. That in itself can be difficult, because sometimes family members don't necessarily have a kind of an understanding of the level of concern that the local authority has for the child. That can be sometimes, the parents have found it difficult to share the fact that the local authority are involved, or if they have shared that we're involved, not necessarily shared the level of concern. And that might be understandably through sort of parental shame or embarrassment. Sometimes kind of difficult or fractured family relationships mean that there's difficulty in communicating some of these kind of concerns or issues. So not all kind of members of a family, or both sides of the family, if we think about maternal and paternal, or two maternal sides of a family, they won't necessarily know the level of concern. Sometimes it comes from a place where the parents are consciously or unconsciously not accepting the level of concern, and therefore they won't be communicating that to their wider family. And obviously sometimes there's a lot of anger and mistrust of the local authority, either being driven by the parents, which is then communicated to the wider family, and that can therefore make it difficult for prospective kinship carers to understand the level of concern. And therefore I think that sort of one of the important training messages is that is that you can't judge a prospective kinship carer for not recognizing concerns because they don't necessarily know them. You need to kind of do the work to make sure that you're helping them understand the level of concern, and then from there be assessing their potential protective capacity around that. And I think the other point is that for many prospective kinship carers, it will remain a very hypothetical scenario that you're putting to them, that you might need to care for a child in the network. That can arise from the kinship carers' optimism about the reality of whether or not they will ever actually be needed to care for the child, but they may also be, hugely supporting the parents in their attempts to, kind of change the level of care that they're able to provide. And so it's very difficult for prospective kinship carers on the one hand to be being expected or asked, required by the local authority to be supporting a parent's care of a child, whilst on the other hand sort of psychologically splitting themselves in half and being expected to think, oh, but I might be the one who'll be caring for them in a couple of months. I think it's quite a big ask. So I think we need to kind of remember that it can also be quite a hypothetical scenario. And therefore, it can be difficult to engage with prospective kinship carers in a kind of meaningful way. And again, I don't think that, there should be blame or judgment around that, because I think it's a complex psychological journey to go on becoming a kinship carer. So therefore, information does need to be shared sensitively with prospective kinship carers, and hopefully being able to share information with parental consent is the first sort of stepping point in terms of helping prospective kinship carers have the information that's needed. And also, obviously, within this, with early identification of kinship carers, you always need to be thinking about potential family members overseas. As part of Core and BAF Advice Line service, we have the outbound permanence service, and they're a very rich source of information and advice if you're beginning to explore family members overseas, because it's very complicated and very specific to different countries. But it's important that we do consider them for a child at all opportunities. So when we think about the assessment of prospective kinship carers, there's obviously the initial viability assessment of a kinship carer, and that may well be you if you are a AYSE or student social worker on the call. If you're the child social worker, in many local authorities, it's your responsibility to do the initial viability assessment of a prospective kinship carer, and your local authority will have a template that you would then complete. In some local authorities, they're undertaken jointly with the social worker from the kinship care team, or there might be a social worker in the kinship care team who can provide some kind of consultation or advice around the process of the initial viability assessment, or to kind of help you think through your analysis of the information that you gathered. But from the outset of an initial viability assessment, it's really important that we consider the value or the significance of the pre-existing relationship between the child and the prospective carer, and what it would mean for the child to live with somebody that they already know and trust, as well as thinking about what the child's wishes and feelings are. So we're not completing initial viability assessments of that prospective kinship carer's capacity to care for any child. We're completing an initial viability assessment of their capacity to care for that specific child, holding in mind what their relationship is and what that would mean for the child to live with them. And then if a child becomes a child in care, because the concerns are such that they've either become subject of an interim care order, or the parents have been asked to sign Section 20 and the child has been voluntarily accommodated by the local authority, the kinship carer would then need to become temporarily approved as a kinship foster carer, because children in care are legally required to live in a regulated placement, and therefore the Regulation 24/25 is the mechanism by which a kinship carer can become a temporarily approved kinship foster carer, which means it then becomes a regulated placement and therefore it becomes a lawful placement. It's the Reg 24 and 25 is in the care planning placement and case review regs 2010, and there's a reference to that at the end of the presentation. And as I said at the beginning, if you are interested in the law and want to know more, there is a date on the slide at the end that is the sort of getting started in permanence and thinking about the law, and there would be more around the sort of legal system around this probably in that presentation. As I said before on the previous slide, court timescales, obviously, when we're thinking about care planning for children, are an issue. Obviously, the relaunch of the public law outline and the return to 26 weeks definitely is having an impact on court timescales for assessing prospective kinship carers. Because if you're thinking about, once you're in care proceedings, the sort of 26-week timescales makes it very tight to allow the 12 weeks to assess a prospective kinship carer, but it absolutely is doable, and therefore it is we should advocate always for a minimum of 12-week timescale. But what that does also highlight is the importance of obviously doing the work in PLO as well. So if you are having, if there are increasing concerns about a child's welfare, the work around identifying potential kinship carers, working with the extended family, beginning to support the prospective kinship carers to understand the concerns, completing initial viability assessments, that should ideally all be done in PLO before any applications are actually made to court, because it may result obviously in that work diverting away from even applications being made to court. But if applications are unavoidable, and we know that they sometimes are, then at least that work has been done and started within PLO. Obviously, sometimes there are genuine emergencies and a child, the safety of a child comes to the attention of the local authority and we simply haven't had time to do the work in PLO. And therefore, of course, that work would need to be done as soon as the application was made. But ideally, the work should be done as part of the public law outline work that happens before. There was public law working group guidance issued around the use of special guardianship orders in care proceedings, and that made a few kind of key recommendations. That there should be full and comprehensive assessments completed of prospective special guardians and sufficient time afforded to local authorities to undertake these assessments, and that's where the we have the support therefore for the 12-week timescale. And where a child has not previously lived with the prospective special guardian, that guidance set out the absolute need for the child to be cared for on an interim basis before a special guardianship order can be made. So that becomes known in lots of local authorities now refer to that as the sort of testing out period. So what often happens is an assessment will be completed of a prospective kinship carer. It might be then while the child is living somewhere else, potentially still at home with parents, or potentially is in unrelated foster care. But then the child would, on the basis of the sort of assessment, the child would then need to move to live with the prospective special guardian before the final order could be made. And then obviously updating statements would need to be filed in court to update the court on the nature of the relationship that's then building between the child and their prospective special guardian. So the National Kinship Strategy, as that I mentioned sort of right back at the beginning of the presentation, it doesn't say a huge amount about the assessment of prospective kinship carers, despite the fact that we know it is such a huge and complex area of work for local authorities. But it did say very clearly, when a kinship carer is formally assessed, the assessment process will be reasonable, proportionate, and treat family members with trust, while prioritising the safety of the child. And that is quite a helpful kind of catch-all sentence to just kind of hold on to when we're thinking about the assessment of prospective kinship carers. And so Core and Bath, as you know, is also a publisher of forms that many local authorities use under licence from Core and Bath. We previously published Form C, which stood for Connected Persons, and we've just published in February this year a very updated and sort of newly designed Form K, which is an assessment of a prospective kinship carer, hence why it's been renamed Form K. And so in response to sort of various drivers around wanting to improve the quality of assessment of prospective kinship carers, we undertook, working parties, focus groups with kinship carers, with practitioners, with managers, with parents. We piloted a new form, and that all built to lead to the publication of Form K in February, which is a strengths-based and trauma-informed assessment of prospective kinship carers. It prioritises the voice of the child, as well as the meaning of the pre-existing relationship between the child and the carer. As going back to what I was saying at the beginning about the initial viability assessment, it's crucial that kinship assessment work prioritises the voice of the child, where they want to live, what their wishes and feelings are, what it would mean for them to live with that prospective kinship carer, as well as analysing the meaning of that pre-existing relationship. Form K encourages kind of robust analysis, and it has an integral support plan within it. So Core and BAF are of the view that you can't consider assessment of prospective kinship carers without at the same time considering what their support needs are. And therefore an assessment considers what their strengths are, considers their vulnerabilities, considers any risks, and then at the same time, in terms of the analysis of those strengths, vulnerabilities and risks, you're at the same time therefore also analysing, well, what support could enhance their strengths and what support could also mitigate against any risk and vulnerability. We will be publishing, hopefully in June, an updated version of our undertaking kinship assessment guide, which will then correlate to Form K rather than Form C. And I do have a bookshop slide at the end where you'll see the existing version of that book, which will then obviously become the new version. So then thinking about support, as I've said, it is integral to assessment work with prospective kinship carers. But there are a few sort of key points when we're thinking about the support to kinship families that is kind of essential for us to sort of hold in mind, really. First of all, is that obviously kinship families, they're not a homogenous group. Families' needs, children's needs are not static, and therefore support does change and vary over time. So it is important as local authorities that we think about, support being, readily accessible as and when needed. As part of the kinship strategy, the government made a financial commitment to provide a universal support and training offer to all kinship families, regardless of their legal status. So going back, when you think about that, sort of one of my first slides around the different types of kinship arrangements, private foster carers, kinship foster carers, special guardians, carers with child arrangement orders, informal kinship carers, as well as adoptive parents who are a family member or friend. All of those types of kinship carers now have access to a universal support and training offer funded by the government and provided by Kinship, the charity. So Kinship, the charity, essentially won the government tender to provide that. So all local authorities should be signposting their kinship families, regardless of their legal status, to the support and training that's provided by Kinship, funded by the government. So that does also include your informal kinship carers when they first come through the front door. So if a child has been referred through to your front door and there are concerns, it's important that even at that very outset, the social workers at the front door are understanding whether or not that's a kinship arrangement. And if it is a kinship arrangement, even if the needs of the family mean that they won't necessarily be supported by your specialist kinship services, being your fostering team or your permanent services, it's important that even there, your social workers understand they need to be signposting those kinship families on to Kinship as a source of support, because it is government funded. And I guess it's important to sort of reflect in the National Kinship Strategy, the government, made a commitment to supporting funding for kinship families. And the money is obviously the money is there in the charity. It hasn't necessarily come to local authorities, but therefore it is about that is included in terms of thinking about the support that should be available to kinship families. It's just being delivered differently, obviously, by the kinship charity. And all of the sort of legal guidance, there's the statutory guidance that was published in October 2024, as well as even the 2011 statutory guidance spoke to this. It all speaks to the sort of legal sort of need for support to be based on need, not past or current legal status. So we do know that there is some support available to kinship families that is based on legal status, such as eligibility to the Adoption and Special Guardianship Support Fund, access to pupil premium. But with those exceptions, the guidance tells us that support should be based on need, not legal status. We know that that's difficult for local authorities in terms of threshold and prioritising limited resources, but that's a sort of fundamental premise that it's important that we hold on to and at least work towards, even if we know that the reality of it is sometimes different. But it does therefore make us sort of think about the need to think about support to kinship families across the board, from the front door, early help, specialist parenting services, thinking about our partners in sort of education and health and community mental health services, that thinking about support broadly as well. The stat guidance in 2024 also has strengthened the requirement for local authorities to publish what's available to kinship families. There's always been a requirement to publish a family and friends policy that dates back to the 2011 guidance, but the 2024 guidance has strengthened that, and there is now a legal requirement for local authorities to publish a local offer, which sets out what support is available to all types of kinship families. Again, going back to everybody that's on the definition of what is kinship care, any type of family under that definition, what support is available to them should be set out in a local authority's local offer. The Children and Schools Wellbeing Bill that you'll probably be aware that is going through Parliament at the moment, that is strengthening the requirement even further, and that's being very specific in there that the local offer has to be published. The stat guidance is guidance, it will actually be written into law in the bill. So local authorities will kind of not be able to be not compliant with that publication of a local offer. And there's a lot of work going on at the Department of Education and across the sector currently with different sort of sector organisations, including Core and Bath and Kinship, Family Rights Group, Families in Harmony, looking at kind of what constitutes a good local offer and who makes that decision. Is that for practitioners and local authorities to make a decision about what constitutes a good local offer, or should that be kinship families who are being consulted with, and arguably yes, to kind of agree on what constitutes a good local offer? So this all kind of connects obviously to, as I've said already, about the importance of support planning for kinship families. So if you're working with a kinship family, either as an informal carer or as a private foster carer or as a more formal kinship foster carer or as a special guardian or child arrangement order carer, we can't state enough the importance of thinking about what their support needs are and therefore what support can be provided to them and by whom, and that should be set out in a plan. We do know that the provision of support is quite variable around the country. Some local authorities obviously are perhaps a little bit further ahead in kind of developing their services, but we absolutely know that that's often very resource driven. It's not at all a criticism of local authorities. We know how difficult it is, but we also know that therefore what that means for kinship families is that there can be quite a postcode lottery experience for them in terms of what's available. And that includes in terms of what's available in terms of financial support, with some local authorities offering non-means tested benefits, with other local authorities offering very sort of, again, understandably from a resource perspective, but very sort of rigid rules around means testing and availability of financial support. The government in the strategy committed to setting up pathfinders to pilot in up to 12 local authorities non-means tested financial allowances for kinship carers, and the government is working currently with foundations to develop a kind of expressions of interest which will go out to local authorities at some point over the next few months, for pilots to put themselves, for local authorities to put themselves forward to be one of those pilots. Because the government is committed to trying to, achieve some equity in the financial support that's available to kinship families, but it needs to do pilots and pathfinders to sort of navigate the way forward with that, to get the evidence they need essentially to get the Treasury to agree. So there is a lot of work going on around sort of kinship care. So it's an exciting time to be working with kinship families, because there is some positive change, but there's still a long way to go. So I think that brings us up to, as I thought, we've got like about 6 or 7 minutes left for questions. I will just show you these final couple of slides. You will receive slides in the sort of follow-up email that follows the event. So this is a slide that links you to some of the key sort of regulations and strategies and guidance that I've referenced through the presentation. This is a link to some other sort of resources that will be helpful to you, such as a good practice guide published by the Family Rights Group on initial viability assessments. There's also information on the Family Rights Group website about family group conferences. It will become a legal requirement in the Children and Wellbeing's Bill for local authorities to have undertaken some form of family group decision making before during the PLO process before you can make an application to court. So it is essential that we all understand and work towards that. There's a link towards obviously our outbound permanence service, and there's also links to a couple of other bits of research there. These are some of our events that we've got coming up that are kinship related. If you're a member, if your local authority is a member of Core and Bath, then you're entitled to attend our practice forums, and we run 2 kinship related ones. We have a kinship care one, and the next one of that is on the 2nd of July, and that's a booking link that you can book via our website to join that. And we also run a private fostering practice forum, and the next one of that is on the 9th of July, and again that's a booking link. We're also running our 2nd kinship care conference on the 13th of October. Last year's sold out, and so this is a save the date link which you can follow to receive sort of further information and when the bookings go live. And then we do also run training in kinship or aspects of kinship care, and that's a link to our training and events programme. These are just a couple of the Core and Bath books that relate to work with kinship families, and this one on the green one, the Undertaking a Connected Person, Family and Friends Assessment, that's the one that's it's with the typesetters, the latest version of that, and that will become Undertaking a Kinship Care Assessment, and it will be published hopefully in June, and that will be a guide to collecting and analysing information for Form K.